In the dead of night, beneath the canopy of a Southampton County forest, history did not merely breathe. It shattered. If you find yourself drawn to the hidden fractures of the American experience, please consider subscribing to the Ink of History, where we illuminate the shadows of a past that refuses to stay buried. We are looking back to August 21st of 1831. It began as a whisper in the woods, a divine mandate felt in the marrow of one man, Nat Turner. History books often reduce him to a headline, a chaotic footnote of violence, but they fail to capture the tectonic shift he triggered. They fail to explain how 48 hours of terror became the architects of a legal nightmare that would define the American South for the next 30 years. Why was the ink on the legal codes of the South rewritten in the blood of that summer? Why did a single insurrection force a nation to abandon its facade of benevolent paternalism and embrace a regime of total, suffocating control? The answer lies not just in the rebellion itself, but in the silence that followed, a silence crafted by lawmakers terrified of their own shadow. Nat Turner was not a man of simple impulses. He was a preacher, a man who navigated the complex geography of the enslaved mind with a literacy that was, in itself, an act of rebellion. He saw signs in the heavens, blood-red suns, and atmospheric disturbances that he interpreted as divine instructions. To the white plantation owners of Virginia, he was a ghost, an anomaly that shouldn't have existed. To those in bondage, he was a bridge to a radical, dangerous hope. He moved through the tall, tangled grasses of the Tidewater region with a focus that was terrifyingly calm. He believed, with an intensity that defied logic, that he was an instrument of a higher power. As he gathered his small band of followers, they did not move with the frenzied chaos of a mob. They moved with the calculated, heavy steps of men who believed they had already surrendered their lives to a higher cause. The geography of Southampton County was essential to what happened. It was a landscape of isolated farmsteads hidden by thickets and swamps, a place where the distance between master and slave was bridged only by violence and forced labor. When the rebellion began, it was swift and silent. There were no grand warnings. There were no debates held in town squares. There were only the sudden, heavy thuds of steel and the muffled cries that barely broke the humid midnight air. For 48 hours, the rebellion tore through the social fabric of the county. Every home they reached was a microcosm of the systemic tension that had been building for generations. The rebellion was not just a fight for liberty. It was a visceral reaction to a system that treated human beings as capital, as property, as tools that could be broken and replaced. As the movement grew, the terror among the white population became absolute. They saw in the eyes of their own laborers not the submissive, hollow expressions they had been promised, but a reflection of their own vulnerability. As word of the uprising traveled, the state of Virginia descended into a state of hysterical paralysis. Militia units were mobilized, not with the grace of a professional army, but with the frantic, disjointed panic of men who feared their own homes were being turned into battlefields. The response was not merely military, it was a vengeful, indiscriminate fury. For every victim of the rebellion, a dozen innocent individuals were slaughtered, their bodies left in the fields as a grisly warning against the audacity of dreaming of freedom. But even as the rebellion was crushed, the true transformation of American law was just beginning. Legislators in Richmond convened with a singular, desperate mission: to ensure that this silence, this fear, would never be challenged again. They realized that the greatest threat to their way of life was not just the sword in the hand of the rebel, but the word in the mouth of the preacher, the letter on the page of the literate, and the gathering of voices in the dark. The legislative response was a masterpiece of reactionary engineering. They understood that to prevent another Nat Turner, they had to dismantle the very humanity of the enslaved population. They passed laws that made it a crime for any person of color, free or enslaved, to preach or exhort. They tightened the iron grip on education. Literacy, long seen as a dangerous luxury, was now treated as a weapon of mass destruction. To teach a person in bondage to read was to invite the fire of insurrection. These laws were not just about control, they were about the systematic erasure of intellect. They sought to render the population a monolith, a silent, unthinking machine that could be lubricated by the lash and fueled by the fear of the unknown. They redefined the legal status of the enslaved, narrowing the paths to freedom until they were non-existent. They stripped away the modest freedoms that had existed in the gray areas of the law, creating a binary world where only the master and the property existed, with no room for ambiguity. The paradox of the 1831 rebellion is that it achieved the exact opposite of its intended goal. While Nat Turner sought to shatter the chains, his actions provided the justification for welding them shut. The panic of the slaveholders became the foundation for the most draconian legal codes in American history. They codified their fear into state statutes, turning the entire legal system into a manifestation of white supremacy that would persist, in various forms, for more than a century. The court records of the time show a desperate attempt to legislate the human spirit out of existence. They tried to regulate the way people walked, the way they gathered, and even the way they looked at one another. They were building a fortress, but the reality was that they were building a prison for a nation that was already fracturing. Historians often overlook the sheer scale of the legal shifts that followed these 48 hours. We focus on the violence because violence is visceral, but the law is the true record of power. The laws passed in the wake of the rebellion were designed to institutionalize paranoia. Every neighborhood had its own watch, every interaction was scrutinized, and the state became a pervasive presence in the lives of the marginalized. The fear of another Nat Turner became the ghost that haunted every major political debate in the South. It stifled dissent among the white population as well, forcing them into a rigid ideological conformity. If you spoke against the institution of slavery, you were no longer just a political opponent. You were a traitor, a potential accomplice to the next bloodbath. The rebellion had effectively silenced the South, creating a vacuum where only the defense of slavery could be the primary topic of public life. The mystery of Nat Turner remains, in part, because his own voice was filtered through the biased pen of a white attorney, Thomas Gray. In the document known as the Confessions of Nat Turner, we hear a man who is both resolute and hauntingly detached. Is this the real Nat Turner, or is it a portrait painted by a man who needed to believe that Turner was a madman, a delusional religious fanatic, rather than a man driven by the cold, hard reality of his existence? By framing Turner as a monster, the legal system could justify the extreme measures they had already decided to implement. If he were a monster, the laws were a necessary medicine for a sick society. If he were a man, the laws were a confession of guilt. The narrative of the madman was essential to the survival of the legal myth they were building. It allowed history to categorize the uprising as a tragedy of insanity rather than a political crusade. As we look back at the 48 hours that changed the legal landscape, we must ask ourselves what we are choosing to remember. Memory is a selective process. We remember the names of the leaders, the dates of the battles, and the broad strokes of the decrees, but we often forget the daily realities of the people who lived under these laws. We forget that these laws were not abstract concepts, they were lived experiences. They were the reason a mother would hide her literate children, the reason a prayer meeting would be held in the silence of a cellar, and the reason that every breath taken in freedom was a breath stolen from the state. The legal history of the United States is deeply tethered to this moment. The impulse to control, the fear of the uprising, and the desire to legislate away the humanity of the marginalized are threads that run through the tapestry of our national identity. The aftermath of the rebellion taught the American South that power, if left unchecked, will always seek to insulate itself from the consequences of its own brutality. The legal changes were not just reactions. They were preemptive strikes against the future. By criminalizing the very components of personhood, education, assembly, and spiritual autonomy, the state sought to ensure that no future Nat Turner could ever arise. Yet, seeds of resistance were planted in the very soil that was being salted. The more the law sought to suppress the human spirit, the more the spirit found ways to navigate the shadows. The rebellion was not a failure because it ended in defeat. It was a catalyst that exposed the fragility of the entire social experiment. It revealed, in the starkest terms possible, that a society built on the denial of rights will always live in terror of the day those rights are demanded. How do we reconcile these pieces of history that have been tucked away in the dusty corners of legal archives? We must acknowledge that the laws written in 1831 were not just relics of a lost cause. They were the blueprints for a system of control that evolved alongside the nation. When we examine the rise of modern mass surveillance, the policing of marginalized communities, and the systemic barriers to justice, we see the echoes of those same fears that haunted the Virginia legislature. The ghosts of the Southampton uprising never really left the courtroom. They are there in the precedents we cite, in the structures we uphold, and in the way we continue to grapple with the legacy of a nation that was built by those it sought to break. The story of the rebellion is often told as a closed chapter, a finished struggle that ended on the gallows where Nat Turner met his fate. But the legal implications were the prologue to a long, arduous century of struggle for what we now understand as basic human rights. The system that was perfected in the 1830s was designed to be permanent, to be immovable, to be the absolute authority. Yet, the history of the marginalized is a history of outlasting the systems that attempt to contain them. What was once a whisper in the woods of Virginia became a roar that eventually reached the halls of power, leading to the eventual dismantling of the very codes that were forged in the heat of that panic. But the process was neither quick nor complete. The remnants of those laws, the psychological weight of that control, and the structures of inequality that were solidified during that period continue to influence the ways in which we experience justice today. There is a profound, lingering mystery in how easily such a monumental shift in law has been relegated to the background of national memory. Perhaps it is because the truth is uncomfortable. It is easier to believe in the triumph of ideals than to face the reality of a legal system that was, at its core, a defensive weapon used to maintain a state of permanent servitude. When we study the American past, we often look for heroes and villains, but the history of the law is far more complex. It is a history of compromise, of fear, and of the constant negotiation of power within a framework that was fundamentally compromised from the start. We must look closer at the testimonies of those who lived through these changes, those who kept their journals hidden, who taught their children in secret, and who continued to believe in a future that the law told them was impossible. Reflecting on these events, we are reminded that memory is not just a passive act of remembering, it is an active engagement with the present. Every time we challenge a narrative, every time we dig into the archives, and every time we ask the difficult questions about the origins of our legal standards, we are continuing the work of understanding our own place in history. We are not just passive observers. We are the descendants of those who lived through the fear, the struggle, and the eventual dismantling of these systems. We carry the responsibility of telling these untold stories, of bringing the light of inquiry to the dark corners of the past, and of ensuring that the sacrifices made in those 48 hours are not reduced to a mere lesson in a textbook. As we conclude this investigation into the 1831 paradox, consider the depth of what we have uncovered. The law is not a static monolith. It is a living document that records the anxieties, the fears, and the ambitions of those who write it. By understanding how the rebellion of Nat Turner transformed the legal landscape, we can better understand the forces that continue to shape our world today. We invite you to join us in this ongoing exploration of the shadows. The ink of history is a commitment to the truth, to the stories that have been shaped by the power of the state, and to the enduring resilience of those who refuse to be defined by it. If you have been moved by this exploration of the past, we urge you to share this story, to spark a conversation in your own community, and to keep the dialogue about our collective history alive. There is so much more to uncover, more stories waiting to be told, and more truths to be unearthed. Subscribe to the Ink of History, engage with our content, and help us continue to illuminate the untold narratives that have defined our world. The past is never truly behind us. It is always present, waiting to be understood, waiting to be heard, and waiting to be brought into the light. Thank you for walking this path with us, and we look forward to the next discovery in our quest to understand the complex, fractured, and beautiful history of the American experience. To truly grasp the magnitude of the 1831 shift, we must look beyond the immediate legislative panic and examine the broader psychological transformation that took hold of the American South. The rebellion was not merely an event, It acted as a violent catalyst that calcified the divide between the humanity of the enslaved and the economic machinery of the state. When we peel back the layers of those frantic courtroom proceedings and the subsequent tightening of the slave codes, we see a society losing its grip on the very morality it claimed to uphold. The transition from a tentative, often contradictory system of control to the rigid, absolute authoritarianism that defined the pre-Civil War era is a story of fear trumping reason. Think of the intellectual atmosphere of Virginia in the summer of 1831. It was a place where Enlightenment ideals still echoed in the halls of government, yet those same halls were simultaneously being shuttered against the possibility of abolitionist thought. The paradox deepens when you realize that the lawmakers of the time were not ignorant men. Many were well-versed in the theories of natural rights and the rhetoric of the American Revolution. Yet, the presence of the rebellion forced them into a cognitive dissonance so profound that it necessitated the total silencing of the enslaved population. They didn't just pass laws to stop insurrections. They passed laws to stop the exchange of information. The prohibition of literacy for the enslaved was the ultimate admission that the system could not survive under the scrutiny of an educated mind. It was a concession that their order was built on a foundation of sand, held together only by the denial of the written word. When we investigate these archives, we often focus on the men in the high offices, the governors, and the judges. However, the real history is found in the margins, in the testimonies of the enslaved individuals who were forced to navigate this tightening web of legislation. Consider the emotional weight of being forbidden from gathering, from preaching, or from communicating in any way that the state deemed a threat. The resilience required to maintain a sense of self in that environment is staggering. This was not a passive existence. It was a constant, tactical navigation of a world designed to crush the spirit. By examining the legal restrictions, we are also mapping the boundaries of that resistance. Every law that was added to the statutes was a reaction to a form of agency that the state had failed to suppress. Let us widen the lens further to include the role of the press during this era. The newspapers were not mere reporters of events, they were architects of the public consciousness. In the aftermath of 1831, the rhetoric shifted from a debate about the morality of slavery to an existential defense of the plantation system. Editorialists began to frame the legal crackdowns as a humanitarian necessity, claiming that the state had a duty to maintain order for the protection of everyone, including the enslaved. This gaslighting of history is a common thread throughout the American experience. By justifying the erosion of rights as a necessary sacrifice for stability, the state effectively sanitized its own brutality. This is a pattern we see repeated in various forms throughout our history, where the language of security is used to strip away the protections of the vulnerable. Furthermore, we must look at how these legal precedents influenced the broader political landscape of the United States. The Southern obsession with state sovereignty, which would eventually lead to the secession crisis, was deeply rooted in these post-1831 anxieties. The federal government was viewed with suspicion precisely because there was an underlying fear that someone, somewhere, would eventually listen to the voices of the oppressed. The legal framework built to contain the rebellion became the legal framework that would eventually tear the country apart. It is a cautionary tale about how the refusal to address the fundamental contradictions of a society can lead to a hardening of positions that precludes any peaceful resolution. As we continue to dig through these records, we are confronted with the reality of what happens when a legal system is tasked with defending an indefensible practice. It leads to the creation of a shadow jurisprudence, a set of rules that exists specifically to bypass the principles of justice in favor of expediency. When you look at the trials, the lack of due process, and the summary executions that characterized the state's response, you realize that the law had been stripped of its moral authority. It had become a weapon rather than a shield. This is the core of the 1831 paradox. The very institution designed to uphold civilization was used to dismantle it. We must also contemplate the individuals who stood against this tide. The abolitionists of the era, who faced social ostracization and legal threats for the simple act of pointing out the hypocrisy of their neighbors, deserve a more prominent place in our historical narrative. They were the ones who dared to suggest that the law should be synonymous with justice, not just the preservation of power. Their voices were drowned out by the roar of the legislature and the click of the shackles, but they kept the flicker of humanity alive. By uncovering their stories, we find the courage to challenge the systems of our own time. History is not just a catalog of the powerful, it is a repository of the struggle against power. In our future investigations, we plan to look specifically at the role of the local militias and their integration into the legal apparatus of the state. These were not just soldiers, they were private citizens granted the authority of the law to act as judge, jury, and executioner. This blurring of the lines between private violence and state-sanctioned force is a crucial component of the story. It reveals how the state outsourced its cruelty to the populace, creating a culture of complicity that made the institution of slavery an inescapable part of daily life for every white citizen, whether they owned enslaved people or not. The law was the glue that bound them all to the same ethical cliff. As we wrap up this current arc of our study, I want you to remember that the archives have a way of speaking back to us. When we ask the right questions, when we look at the documents not as inert objects but as vibrating remnants of human conflict, the past begins to reveal its secrets. The 1831 rebellion was a rupture, a moment where the veil was torn, revealing the machinery of control that usually operated in the background. Understanding that moment allows us to understand the mechanisms of control that still operate today. The names might change, the tactics might be modernized, but the impulse to define, to limit, and to suppress remains the same. We invite you to consider the sheer effort it took to maintain this control. The records show an obsessive level of detail in the monitoring of the enslaved, from the passes required for travel to the meticulous accounting of human lives as property. This bureaucracy of bondage is a chilling reminder that the machinery of oppression is always data-driven. They were obsessed with knowing, with tracking, and with categorizing. Our work here at the Ink of History is to reclaim that data, not for the sake of the state, but for the sake of the individuals whose lives were reduced to entries in an ledger. We are building a counter-archive, a collection of truths that centers the human experience over the bureaucratic record. The road ahead is long and, quite frankly, difficult. We will be traversing some of the most painful chapters of our collective narrative. But there is a profound necessity to this work. We are not just historians, we are stewards of a memory that the state would prefer to keep buried. By bringing these stories into the light, we are performing an act of restoration. We are acknowledging that the victims of these laws were not just passive subjects of history, they were agents of their own destiny, even when that agency was manifested through the defiance of the law itself. I want to thank you for staying with us through these dense, often uncomfortable layers of legal history. It is easy to look away, to focus on the brighter aspects of our past, but that is a disservice to the truth. The American experience is not a singular, triumphant narrative. It is a complex, often contradictory story of triumph and tragedy, of liberation and enslavement, and of a constant, ongoing negotiation with the concept of freedom itself. We are all participants in this negotiation. Our laws are still being written, and our history is still being interpreted. By engaging with these difficult questions, you are helping to shape that future dialogue. Stay with us as we move into the next phase of our research. We have uncovered documents that suggest the influence of the 1831 events reached far further north than previously documented, touching the political discourse of Philadelphia and New York in ways that shifted the approach to the abolition movement. There are links we are still connecting, leads we are still following, and stories that are begging to be told. The archives are vast, and the shadows are deep, but we are committed to the light. This is not just a project about the past. It is a project about the future of our society and the values we choose to uphold. As you reflect on the 1831 paradox, ask yourself what it means to live in a country where the law has been used as a tool for division. How do we reclaim that law for the purpose of unity and true equality? How do we address the systemic legacies of these laws that still impact our communities today? These are the questions that drive our work. We aren't looking for easy answers. We are looking for the truth, no matter how fractured or uncomfortable it may be. The Ink of History is more than a series. It is a collective effort to reckon with who we are and where we have come from. Thank you for your curiosity, your diligence, and your willingness to sit with these questions. Your engagement keeps this dialogue moving forward. As we prepare for our next deep dive, we encourage you to look at your own surroundings, at the history of your own city or town. What stories are hidden there? What laws were passed in the wake of crises that still linger in the structure of your community? The past is never truly gone. It is in the architecture, the court systems, and the social dynamics that define our daily lives. Join us as we continue to shine the light of inquiry into these dark, necessary corners. There is so much more to uncover together, and we are just getting started. The journey into the heart of the American experience is a long one, but it is one that we are honored to take with you. Every document unearthed is a piece of the puzzle, every story told is a step toward understanding, and every voice raised in these archives brings us closer to a history that finally acknowledges the full, complex, and beautiful reality of our shared human experience. Until next time, keep questioning, keep digging, and keep seeking the truth hidden in the ink of our history. The records are waiting for us, and the truth, as always, is ready to be told. To understand the full weight of these archived truths, we must shift our focus from the broad strokes of constitutional debate to the granular reality of the local ledger. It is easy to view history as a series of monumental decisions made in marble halls, but the true pulse of an era is often found in the mundane minutiae of municipal ordinance and county court filings. When we examine the aftermath of the 1831 legislative shifts, we see a ripple effect that transformed not just the courtroom, but the very way people navigated their daily existence. It was in the licensing requirements for street vendors, the restrictive covenants buried in property deeds, and the peculiar vagrancy statutes that suddenly seemed to target specific populations with mathematical precision. These were not accidents of bureaucracy, they were targeted interventions designed to reshape the social fabric. Consider the role of the clerk, an often overlooked figure in the annals of power. In the early 19th century, the clerk was the gatekeeper of reality. If a transaction wasn't recorded, it didn't exist. If a name was misspelled or a pedigree omitted, a person's entire legal standing could vanish overnight. By tracing the ink of these clerks, we begin to see a pattern of exclusion that was so systematic it almost masquerades as incompetence. We find that certain districts were consistently underreported, while others were meticulously documented. This archival bias wasn't merely a lack of resources, it was a deliberate choice regarding whose life was deemed worthy of preservation in the official record. By choosing to ignore the contributions and the presence of marginalized groups, the state effectively erased their history before the ink had even dried on the page. As we peel back these layers, we find ourselves confronting the uncomfortable reality of the paper trail. We have spent the last few months analyzing the specific language of the 1831 statutes, but now we must expand our scope to include the broader cultural and economic landscape. Why, for instance, were the industries of the North so inextricably linked to the labor practices of the South, even when the legal frameworks seemed to suggest a growing divide? The answer lies in the ledger books of shipping companies, the trade agreements between textiles mills, and the insurance policies taken out on human beings. When you look at the raw numbers, the moral arguments of the time begin to look like a flimsy veneer over a hard, cold economic engine. The law was not just a protector of rights, it was a facilitator of commerce, and often, that commerce required a complete suspension of the very principles the country claimed to hold dear. This brings us to the concept of complicity. It is natural to look back and point fingers at the architects of these exclusionary laws, but what about the silent partners? What about the citizens who, while perhaps not drafting the legislation, benefited from the stability it provided? When the law creates a hierarchy, everyone living within that system, whether they realize it or not, is participating in its maintenance. We are currently sifting through a collection of private correspondences from that period, letters written by merchants, school teachers, and family members. These documents provide a lens into the normalization of injustice. You see people writing about the most horrific events with a chilling, detached normalcy. They discuss the price of goods, the weather, and the latest court ruling in the same breath, illustrating how thoroughly the injustice of their time had been integrated into their worldview. This is the most difficult aspect of our research. It is much easier to confront a monster than it is to confront a neighbor who simply accepted the status quo. Yet, if we are to truly understand the roots of our current systemic challenges, we must grapple with this domestic complacency. We must ask ourselves why it is so easy for a society to ignore the suffering of others when that suffering is codified by the state. Are we so different today? We have moved beyond the overt, written laws of the 1830s, but we still live amidst the structures they built. Zoning laws, school funding formulas, and historical monument placement. These features of our modern environment are all, in a sense, the ghosts of old agendas. They continue to shape our outcomes, even if the original intent behind them has been obscured by time. As we move forward into the next phase of this project, we are going to pivot toward the voices of resistance. It is important that we do not frame our history purely as a story of top-down oppression. Throughout every period of our history, there have been individuals who recognized the injustice of the law and chose to defy it. We are currently working to transcribe a cache of documents related to secret aid networks, underground petitions, and legal challenges that were filed by those who had the least to lose and the most to gain. These stories are often harder to find because they were intentionally suppressed by the authorities of the day. They have been hidden in attics, tucked into the backs of family Bibles, or buried in the archives of religious organizations that dared to document what the state refused to acknowledge. Finding these narratives is like assembling a mosaic from scattered stones. Each story is a fragment of a larger picture of defiance. We have discovered accounts of lawyers who took on cases that were considered unwinnable, sacrificing their reputations and livelihoods to force the court to confront its own contradictions. We have found letters from mothers who taught their children to read in secret, knowing that the act of literacy was a revolutionary defiance of the statutes of their time. These are the narratives that give us hope, not because they always resulted in immediate change, but because they prove that the human spirit has always possessed an inherent capacity for justice, even when the law is designed to crush it. It is also worth noting the evolution of the language of the law itself. In the 1830s, the legal prose was heavy, ornate, and intentionally opaque. It was written to exclude the uninitiated, to create a barrier of complexity that required a professional class of interpreters to navigate. By tracking the changes in legalese over the decades, we can see how the state slowly solidified its control over the population. The shift from vague, moralistic language to the cold, clinical, and technical language that we see in the late 19th century marks a dangerous transition, the moment when the law stops trying to justify itself through ethics and starts justifying itself through process. This, essentially, is the birth of modern institutionalism, where the way things are done becomes a more powerful force than the reason why they are done. We are now preparing a new series of reports that will map these legal shifts against the demographics of the cities we are studying. By layering historical census data over the implementation of specific ordinances, we hope to visualize the exact moment when certain neighborhoods began to lose their political voice. This is not just about historical analysis. It is about creating a tool for civic literacy. If we can show people exactly how their local laws were engineered to produce specific social outcomes, we can empower them to question the ordinances being passed in their own city councils today. History is a diagnostic tool. If you don't know the nature of the infection, you cannot possibly hope to treat the patient. As we work through these thousands of pages, we are often struck by the sheer volume of paper involved. In an era without computers, the amount of administrative labor required to enforce a system of inequality was staggering. It required an army of clerks, registrars, and officers, all dedicated to the maintenance of a bureaucratic nightmare. This realization changes the way we view the era. It wasn't just a matter of a few men in power, it was a massive, collective undertaking. It was a societal investment in keeping things exactly as they were. Understanding this scale is crucial. It suggests that the unraveling of these systems is equally large in scale. It is not enough to change a single law or to elect a new leader. We are talking about the slow, deliberate work of thousands of people choosing to build something new, something that operates on a different set of principles. We have invited several guest researchers to join us in this final push. Their expertise in linguistics, urban planning and sociology has helped us interpret the data in ways that we never could have imagined on our own. For instance, the way a street was laid out in 1845 may seem like a trivial detail, but when you realize that the street was designed to act as a physical buffer between two different socio-economic districts, the entire urban plan takes on a more sinister character. We are finding that many of our modern cities are essentially living, breathing maps of old prejudices. The infrastructure itself is a testament to the laws of the past. There is a profound sense of responsibility that comes with this work. When you handle a document that hasn't been read in nearly 2 centuries, you feel a visceral connection to the person who wrote it. You are, in a sense, their final audience. They were not writing for us, they were writing for the record, but we are the ones who are finally listening. This connection demands a certain level of integrity. We cannot project our contemporary values onto these documents too quickly. We must allow them to speak in their own voice, even if that voice is filled with hate or ignorance. Only by looking at the reality of their prejudice can we truly understand the depth of the progress that has been made and the distance that we still have to travel. As we bring this chapter of our collective inquiry to a close, we find ourselves standing at the edge of a new understanding. We have moved from the broad, abstract questions of the paradox to the granular, specific realities of the legal machinery. We have seen how the law was used to divide, how it was used to erase, and how it was challenged by those who refused to be silenced. The ink of history has dried, but as we continue to study it, we are finding that it still has the power to stain our present. It is a messy process, and it is rarely comfortable. But it is necessary. If we are to build a future that is truly inclusive, we must first look at the foundation upon which we are building. We must acknowledge the cracks, the errors, and the intentional flaws that were built into the design. Looking ahead, we invite you to continue this journey with us. The archive is vast, and we have only just begun to scratch the surface. We plan to move our focus next to the Reconstruction era, a period where the legal system struggled to reconcile itself with the promises of emancipation. If the 1830s represented the consolidation of the old order, the 1860s and 70s represent the chaotic, often violent attempt to redefine it. The laws that emerged during that time are the ancestors of the ones we grapple with today, and the stories hidden in those records are perhaps the most vital ones we have yet to uncover. We thank you for the patience you have shown as we navigated the complexities of these early records. We know that this is not light reading, and we appreciate the intellectual labor you have contributed simply by staying engaged. The truth is not a destination, it is a way of traveling. It is a process of constant questioning, of digging deeper, and of refusing to accept the official narrative at face value. It is the work of a citizen in a democracy, the work of holding the past accountable to the future. As you step away from these pages, we challenge you to look at the world around you with a new set of eyes. Visit your local library, search the digital archives of your state's historical society, or find the original charters of your town. Ask yourself, who was this for? Who is this meant to exclude? What was happening in the country that made someone feel that this specific law was necessary at that specific time? You will be surprised at what you find. You will see your own community in a completely new light. You will see that you are living in a history that is still being written, and that the ink, while long dried on the page, is still very much a part of the air you breathe. The journey continues. We are not just uncovering the past, we are reclaiming our agency within the present. By understanding how the systems of power were constructed, we finally gain the tools to dismantle, modify, or rebuild them into something that truly represents the ideals we claim to hold dear. The records are there, waiting for us to read them. The witnesses of the past are waiting for us to hear them. And the truth, that elusive and necessary truth, is waiting for us to claim it. Let us move forward with courage, with curiosity, and with an unwavering commitment to the work ahead. The ink of our history is deep, but it is not bottomless, and together, we will find what lies beneath.